Hello everyone. Today I want us to talk about divorce, the grounds and the process. Number one, divorce in Kenya is not by consent. There's nothing like signing of papers when it comes to the system of divorce in Kenya. Divorce in Kenya is a court process whereby a party files a case, the other party responds, evidence is interrogated, and a judgment is entered. So there's no such thing as signing of papers and me refusing to sign papers, as many of you are asking me in the DMs. There is no such system in Kenya. What are the grounds for divorce? I want you to know that under the Marriage Act, it is provided that for one to be eligible to file for divorce, that marriage must have lasted for 3 years. This thing is under debate. There's been a case that has been taken to court over that. But what the Act says is 3 years for you to file for any matrimonial cause. Number two, I also want you to know that you can, instead of going for divorce, you can opt for judicial separation, where you are just separated as you leave room for reconciliation. So that in case you reconciliate, you do away with the idea of divorce. If you cannot, then you proceed to file for divorce. Another thing that I want you to know is that you can equally file a separation agreement. The Marriage Act provides for that. The two of you can separate for 1 year. You get an agreement on how to deal with the family matters, properties, and children. So on the grounds, what are the grounds for filing for divorce? Number one, the obvious one, adultery. We file for divorce on grounds of abuse. When I talk about abuse, I'm talking about emotional abuse, physical abuse, any kind of abuse that is just affecting your life. And abuse upon you and your children. That is a ground for divorce. Cruelty, desertion, neglect. And the Marriage Act introduced a new ground called irretrievable breakdown of marriage. When I say irretrievable breakdown of marriage, I mean that the marriage cannot be retrieved, that regardless of the fact that these other grounds cannot be proved, this marriage has gone to a point where we cannot retrieve it. That is why we call irretrievable breakdown of marriage. And this ground is so wide and open that so many people rely on this ground to win divorce cases. So what is the process of filing for divorce in Kenya? You need to file a petition, attach a verifying affidavit, your list of documents, list of witnesses' statement, and a notice to appear. This notice to appear it acts like a summon. It is something that you use to serve the other party to come on record or to enter appearance. So you'll also prepare a notice to appear, which will be signed and issued by the court. So how is a petition for divorce roughly looking like? So this is how it sounds. Petition for divorce. Divorce matters are taken at the lower court, magistrate court. They don't go to the high court. So you'll petition the magistrate court. You will say that you are the petitioner and the respondent. You are both citizens, that you had been married at this day. If it is and remember, divorce is only for marriages that there is a marriage certificate. Kamwe stays, we don't do divorce. You just the way you came in is the way you walk out. So in this case, we are looking at, I'm going to read for you an example. A petition for divorce is a petition. You will state the date when the two of you are married, that the petitioner and the respondent solemnize their marriage at Methodist Church in Kenya. On this date, you attach that marriage certificate. You say that as a celebration of that marriage, you lived as husband and wife, where you lived, and how many children you are blessed with. In court, we call them issues. You state them, and then you said the reason why you're separating. In this case, this one was saying that the petitioner and the respondent separated due to irreconcilable differences whereby they were able to sustain a cordial relationship or live together happily. They have since to date been separated and resumed cohabitation, and the said separation persists. You proceed on to state that there is no hope or possibility of reconciliation or compromise of whatever kind or nature occurring between the petitioner and the respondent. And as such, the marriage between the petitioner and the respondent has broken down. That there has been no proceedings, and wherefore that the marriage between the petitioner and the respondent be dissolved. That is how that petition generally sounds. You attach a verifying affidavit, you attach a list of witnesses, you attach a list of documents, and you attach any evidence. If maybe you are claiming that you had been beaten, domestic violence, you'll attach the evidence of, if you ever have any medical reports, you attach that evidence. But I want you to understand that even if you have no evidence, you can always get divorced because of that ground that I told you earlier, irretrievable breakdown of marriage. In as much as you are divorced, as you do not have any evidence, a marriage that has irretrievably broken down, it means that the court cannot retrieve it no matter what. If you are saying you don't want to be in this marriage, and he's equally on the other end saying his own things, whatever, the court clearly will say that the two of you don't want to be together. If you come to court and say, oh, he has been cruel, he has been treating me badly, and you don't have evidence, who has the evidence of emotional abuse? You don't have the evidence. But the court will just simply look at it and look at how the proceeding goes, and it will just say that the two of you, that marriage cannot be retrieved. And as such, it will issue a divorce decree. Remember, when the court is issuing a divorce decree, the first decree is called a decree nisi. Once you make a decree nisi, you then go and obtain a decree absolute. This is how a decree nisi sounds. This cause coming up for judgment on this date before this judge, in the presence of the advocate for the petitioner and in the absence of the respondent, and upon hearing, reading of the say, it is hereby decreed that the marriage between the two has been dissolved by reason that the marriage has irretrievably broken down on the grounds of irreconcilable differences. Then unless sufficient cause be shown to this court why this decree should not be made absolute upon the expiry of 90 days from the making hereof. So you've heard the decree is issued for 90 days. It's just giving you room that in case maybe you want to change your mind, the court can not proceed to like divorce you. It's like a warning sign telling you guys that we are gonna declare you divorced. So if there's any room between 90 days for you to reconcile, can you reconcile and come back to us? So if you don't, the court will proceed to issue something that we call a certificate of decree nisi absolute, which simply just now completes the whole process that the two of you are divorced. Remember, you don't need to contest a divorce proceeding to make it, just make it easy for the other party. If the two of you decided that that marriage is not going anywhere, someone can just file the petition and the other party will simply just ignore it. That it goes undefended and the court issues orders. The only time you'll be interested to put a response in a divorce proceeding is if they have mentioned property. Sometimes in divorce proceedings, someone can file the petition and include properties that he wants the court to declare them as matrimonial property. In that case, you can go to court and defend yourself so that you don't get declarations that are adverse to your interest. But in any case, if it is just mere divorce, I just suggest that you let the other party argue the case. It goes undefended and the divorce finalizes faster. I hope with this, you now have an idea of how divorce goes in Kenya. Have a great one.